Hi, this is Ken Parker. Welcome to another episode of Legal Angle, the show where we talk about issues in the news
from a legal perspective.
Hey, Matt. How's it going, man?
Really good. How are you, Ken?
Great, thanks. Happy New Year.
Happy New Year. I know this is our first show since the turn of the calendar. Welcome to 2025. It's been an exciting year so far.
Oh, let's not talk about it. I mean, let's talk about it, but let's not talk about it.
But only about the legal issues.
Right.
Because that's the topic of tonight's show.
Well, let's. I think because it's been such a shock to the system, let's not talk about the Washington, D.C. based, change of administration based legal issues. This show just happened a week ago yesterday. There was a new president put in. There's been some policy things. I think we need a little time to process before we talk.
Some policy things.
Some policy things.
Fair enough, Ken. That is a very brief summary of the past 8 days.
I mean, look, if we need to, at the end of the show, maybe a little teaser for a discussion on the next show about some of those policy things. But I think we should focus tonight on some of the, let's put it this way. We got to do our public domain discussion, right?
That's right, because the calendar's ticked over, and so there's new things, new creative works that have entered the public domain that were protected by copyright, are no longer protected by copyright.
They're in the public domain. They're yours, Matt.
I know.
You can do whatever you want with them.
You know what, Ken? I am very much looking forward to more Winnie the Pooh slasher films, and I'm not gonna tease until we get to the topic.
Yeah, no, I hear.
What slasher films and ridiculous.
But it's not just that, because some of that might be parody too. You can just make a straight up, like Sherlock Holmes, for example, now, right?
Yes, that's right. You could just write new Sherlock Holmes stories. They don't have
and
to
make
be
movies. You can use the character.
Right. They don't have to be parody or slasher films.
Right. And so we got public domain, but we also, you and I are both intellectual property attorneys.
Yes.
I am so excited about asking you about what I think is one of the most bizarre patent-related court decisions I have ever read. And you're going to have to talk me down from thinking this is just weird, because
I'll do my best, but as with anything in any legal practice, there are no guarantees.
All right, well, fair enough. You do your best to talk me down,
Yes.
and then I know there's also a couple interesting copyright suits going on.
Always, yes.
Yeah, a couple that we want to talk about on that front. So let's see if we got our rundown here. Let's look at our rundown for the evening. I know that our first was Mickey a naughty mouse?
It may have been.
Yes,
it may not have been. We'll see. But there's a lawsuit about whether or not Mickey misbehaved.
And of course, by Mickey, we mean Disney, because he is their trademark. He is their icon, and so we can refer to.
He is their trademark. He is their copyrighted material, although not.
Oh, no.
No. Hang on, let me
Somewhat.
finish the sentence. Not all versions of him. The earliest version, the Steamboat Willie version.
The characters in the public, as we discussed last year on Public Domain Day.
Because Steamboat Willie entered the public domain January 1st of 2024, a year and a month ago.
And there's more Mickey that's coming into the public domain, but the fundamental character, is in the public domain.
Yes.
So, but he's still a trademark of Disney, so we can ask whether he was a naughty mouse.
Yes.
Then, screening for the obvious, Matt. This is the patent case I can't wait to talk to you about.
I know, so I'm excited to talk about this one too. We will save the spoilers until we actually talk about it. But as with many of our subject titles here, we've got a pun in there.
Oh, well, of course.
Yes.
Isn't
we'll
that?
Screen for the good stuff.
Yeah, so and the fans will be screaming about it. Topic number 3, public access to public access videos. And Matt, obviously, we're discussing it on a public access station.
Well, this one caught my eye because, 1, it's about public access television. 2, it's a Massachusetts case. It's out of actually our neighbor, Waltham. And 3, it raises an interesting question about who's a government actor and who is a private actor, which has impacts on the copyright.
Involves a city council. I was a city councilor here in Newton. I mean, there are so many interesting angles on this one.
Yes.
That one's going to be a fun one.
Yes.
And then, of course, we already said public domain. All right, well, Matthew Yospin, let's rock and roll, man. Let's bring on the first topic.
Very well, Kenneth Parker. Let's do this. So, topic 1, was Mickey a naughty mouse? This is a copyright infringement lawsuit about Moana 2. Ken, I know you've got kids, one of them young. You know I've got kids, both teenagers. I've seen the first Moana, which was, as franchises are often called, just Moana, not with a one attached, not like Moana 2. I haven't seen the second one. I got a review of it from a family member who's got younger kids.
They like it?
Yeah, he did. I mean, I think the kids, my nieces, really enjoyed it.
Well, my daughter's 8.5. She's dying to see it. I told her I haven't seen the first one yet. I got to get caught up before I can take her to see that one. So we're going to probably watch the first one on Disney Plus, and then we'll head out to the theater to watch the second one.
And if you don't have Disney Plus, I'm pretty sure the library has a copy. Our wonderful library system has lots of CDs and DVDs. So, Ken, this one. Now, I just want to say, because we don't want to get sued, the images on screen, one is copyrighted material owned by Disney, which we're using because we're reporting on this topic.
Fair use, my friend.
Thank you. And the other are images from the drawings and other materials.
In dispute in the lawsuit.
Made by a person named Buck Woodall. Now, I won't give you his whole bio, but he's the plaintiff in this lawsuit.
He's suing Disney. He says he's suing Disney for $10 billion. Billion with a B.
Billion with a B, right. So, you know, a billion here, a billion there.
Pretty soon you're talking about real money.
That's right. So, Buck Woodall's complaint is about, well, he's saying that
Both Moana movies.
both Moana movies, except interestingly, he tried to sue over the first one, right? But got foreclosed because the statute of
He
limitations.
waited too long.
Right.
Yeah, statute of limitations. So all our viewers out there, if someone's ripping you off, call a lawyer quickly because time can run out. Copyright lawsuits have a shorter statute of limitations than a lot of other things like contract breach. So you got to jump to it.
Right.
You know.
So he missed his chance to sue Disney over Moana. No one, just Moana.
Yeah, the first Moana. We can call it Moana 1 for purposes of simplicity.
Okay. And
The original Moana movie.
yes. And now he's suing Disney, now that they've released Moana 2, for those $10 billion.
Right.
So Ken, here's my question. I read a story about this. I'm looking at the pictures that Buck Woodall has that were cited among other materials in his lawsuit. I'm looking at Moana. I remember seeing Moana, the original.
Yes. There she is. Standing
There
on the
she is
side
at
of a
top
boat.
with Maui. Okay. These pictures don't look anything like Moana. How is he claiming that the character infringes his character? That's my question.
That is a fabulous question, Matt. The answer is characters have many components and movies have many components. And what he's saying is there are a lot of elements that they have in common. Not the appearance of the character, but the... And let me read down a list to you of some of the things that he says in the complaint they have in common. He said, so Bucky, this is his character with the blonde hair.
Sorry, the character is named Bucky?
Yeah, and his name is Buck.
The
yeah.
illustrator named Buck created a character named Bucky.
It's named after Bucky Dent, the baseball player.
Bucky Dent?
No,
One, I don't believe you. And two, how dare you bring that up here? Bucky Dent? Come on,
it's the only
Ken.
other Bucky I could think of. I don't know.
Ken, baseball been very, very good to me, but but to quote the great and sometimes cheating Sammy Sosa,
Sometimes cheating.
sometimes, but let's
Well, you're on the.
we're still like 3 weeks away from pitchers and catchers reporting.
Yeah, but the equipment van leaves soon from Fenway, and that, as a true Bostonian, is the first day of spring, right?
That's true. I'm just not quite ready to talk about Bucky Dent. in
Okay,
January.
fair enough. Putting aside
Let's get back
what
to the topic.
what the character's name is.
No, I want to ask you this question. I want your reaction to it, not with Bucky Dent. This illustrator named Buck created a character for movies, and named the character Bucky.
Okay, Matt, you're familiar with the franchise called Star Wars.
I am.
Have you noticed that it was created by a guy named George Lucas, and the hero is named Luke? This is very common.
Actually, I'd never put that together.
Oh, really?
I had never put that together.
Okay. Well, epiphany moment for Matthew Yasmin today.
All right. I'll give Buck Woodall a pass here, I guess. So, Ken,
Moving right along.
2025 is going great, Ken.
Okay. Okay.
Okay.
Both Bucky and
You were going to read to us.
I'm going to give you some examples
Yes.
of these are allegations. Now, just to go to Law School 101 for our audience, litigation 101, I should say. When you file a lawsuit, there's one thing that you need to write up before you file the lawsuit. And it is a list, it is a description of what you think somebody did wrong to you. Could be they breached a contract. Could be they stole my car and my car had a certain value. That document is called a complaint, in which you detail the allegations. You don't need proof at that point. You just need to allege what they did wrong. If you fail, if there are times when someone will write up a complaint and they'll accuse somebody of something, and whether it's true or not, it doesn't matter, because the allegations in the complaint, even if true, would not make out claims upon which relief can be granted, because under our laws. So the other side usually will move what's called a 12b6, a motion to dismiss for failure to state a claim. So you want, when you start a lawsuit, you want a thorough complaint that alleges all the details.
Okay.
And you want to allege, and so in this case, Disney said, oh no, we want to dismiss this, there's no allegation. Well, this complaint is solid enough, alleges enough to survive a motion to dismiss.
Okay.
Because it has allegations such as both Bucky and Moana tell the story about a teenager who defies parental warnings and embarks on a dangerous voyage across Polynesian waters to save the endangered land of a Polynesian island. That's the first out of many, many allegations of similarities. Okay. Both Bucky and Moana celebrate what the Bucky script refers to as the Polynesian people's, quote, unfettered access to the sea as a native right. Both Bucky and Moana involve protagonists who learn about ancient Polynesian culture during a sea voyage. And so those are just the first 3 out of something around 30 some odd similarities that they identify. And some of them are very specific. For example, they both talk about, both movies have a vortex that the boat sinks into. So they have a lot, what they're alleging
sucks them
is
to some other realm.
Right, and they both have elements of time travel. So there's a whole lot of plot elements and character development elements and cultural elements that they're alleging. And they're saying, hey, these two things are so similar that you're not taking any one of these things individually might not constitute copyright infringement. But clearly, when you put all these elements together, like all these little dots, connect the dots, you get a picture. Okay. And that picture is too similar. Those pictures are not similar.
So I shouldn't be misled by the drawings that Buck Woodall made of his hero Bucky and the fact that they look nothing at all like Moana.
You shouldn't be misled by that, because it's not like, for example, to use our Star Wars analogy, it's not like someone made someone that looks like Darth Vader. It's like someone who made something that had this. What if you remade the Star Wars movies with lightsabers and the Force and everything else, but you made Darth Vader look like a giant chicken? Okay, it would still. That might be a parody, but you know.
How many years till Star Wars is not protected by copyright?
Star Wars is not connected. Star Wars is not connected by copyright on my 92nd birthday, which is, I know, because that's when we're going to release my film.
All right, so I assume you've got the treatment already ready.
Yes, oh, absolutely.
All right. Okay, well, so that's good to know. So I guess my question about this lawsuit then is, does it have legs, right? I mean, all these items.
Are you sure that's your second question, Matt?
No, I mean,
it's okay. I can answer that one too.
No, because you read off what Buck Woodall says is copied. All these different elements, some of which sound like particular plot points. Some sound like thematic, overarching parts of the story. 2 teenagers fleeing a Polynesian island and sailing off across the ocean in search of something. Rebellious teenagers.
Yes.
Now, how is that protected? Is that protectable?
Great question. So some things are sans affaire, like if you have a dark
what
alley.
Does that mean?
It means scenes, there are generic scenes and generic characters that are not protected. A skulking individual is not protected. A beautiful princess is not protected. You put it, just because something else has a beautiful princess, you can have a beautiful princess in your movie too, Matt.
Right.
A dark alley is not protected. Sans affaire, literally standard scenes.
Right.
But if you put things together, they are protectable, putting together a lot of the same elements. So plot points eventually are, and the question is, how much have you taken? And then the related question is, did you have access to the original? And one thing that this complaint is very heavy on is description of how Buck Woodall sent not only his treatment for the movie, but a mock-up video of it. He had storyboards. He had all these elements, which with a confidentiality agreement, he sent to a Disney executive to review. And he says it was only after they reviewed it that they came up with Moana, the original Moana. And so if a lot of people say, well, what if it's just coincidence that I'm using the same things? How is that infringement? Well, it isn't if it's just coincidence, but they argue it can't just be coincidence. There's too much in common. By random chance, this couldn't happen. So you have to, one of the necessary elements is you have to show that the person had access to what they're infringing. Like if someone were to paint a painting that looks exactly like a painting that you painted, Matt, but your painting is in your basement and you never showed it to anyone, never put a picture on the internet, no one ever saw your painting, even if they painted the exact same painting, they're not infringing your copyright because they haven't been in your house and been to your basement and seen that picture. It would be an amazing coincidence, though. So one of the things you need to prove is that they had access to it. Maybe that person broke into your house and went to your,
Right.
But in this case, there's no question about access, and so this is a fact-specific inquiry as to whether or not these elements taken in combination are protectable. Now, as you and I have talked about before, Matt, there's a huge change in copyright law over the years. It used to be that you couldn't copyright characters and worlds, and like when Sherlock Holmes was written, you know, people made plays with Sherlock Holmes as a character. No one thought you could copyright the character.
Right. Just the actual book,
The story,
each
yeah.
book, each story.
Right.
Yeah.
And now you can't make a Star Wars movie of your own except with permission, essentially.
Right.
They're allowing fan films and whatnot under certain circumstances.
but as we've talked about, not if it's
good.
not if it's really good and looks like a big budget movie and might make a lot of money.
Then they shut it down, and there's been all those lawsuits about Star Trek and Star Wars and other franchises. Now, excitingly, you know, very soon, in a few years, The Hobbit will enter the public domain. Oh, we'll talk about that under public domain.
We'll
I'll
put
tell you
that
what,
on our docket.
Matt, here's what I want to ask you. You can start thinking about this now when we're talking about the public domain.
Okay.
What is the work that will be entering the public domain in the next decade that you're most excited about? I'll tell you right now, The Hobbit is mine because I'd like to.
That's a good choice. I'm going to have to look ahead.
All right.
Make
Okay.
note of that.
Okay, so bottom line here is this is a plausible lawsuit. It's going to be a fact-specific inquiry. We don't know whether Mickey's been a naughty mouse yet. That'll be up to possibly up to a jury, or it may be decided at summary judgment if one side doesn't come up with enough evidence to support their
So
allegations.
you're saying this lawsuit is plausible because there are many allegations of different themes and scenes and characters and plot elements, and because there, at least so far, doesn't seem to be any factual dispute about whether or not Disney had the material.
So A, Disney had access to it. B, there are a lot of allegations of things that are similar. And then it's a fact-specific inquiry as to how similar they are. I mean, so they're literally talking about embarking on a daring voyage on an outrigger canoe. And, you know, Moana 2, in other words, is also alleged to continue this infringement with lots more examples that were in the original Bucky treatment.
Yeah. Well, stay tuned, sports fans. We'll see.
Well, we'll have to have a sequel. Can we call this Naughty Mickey 2? That'll sound too much like
I think Naughty Mickey 2
it's already been made, probably.
I think that's probably already on YouTube.
All right, Matt, I want to ask you about something.
Yes.
I'm so excited to ask you about this, man.
All right.
Okay, so the TSA, everybody loves the TSA.
Yeah.
Because you go to the airport and they give you a big hug and say, welcome.
Ken, pop quiz. What does TSA stand for?
Transportation Security Administration.
Close. That's a second most common answer. It's actually the super agency because everybody loves them. And
They're a super agency? Mm-hmm. Oh, wow.
Yeah. And
Strange agency from another planet. So, Matt, I want to ask you about this. Let me frame it, then let me ask you about it. So, there is, at airports, many airports around the country, TSA wants to look at your laptop, your shoes. They look at stuff, right?
They look at your baggage and your person.
Your carry-ons.
Everything that goes into a secure area.
Right.
In an
So
airport.
whenever you go through that secure checkpoint, you have to empty your pockets, put your hands over your head, walk to the thing. Stuff goes on the conveyor belt.
Right.
So there was a problem that this all picked up with a lot more intense security after 9/11 in the year 2001, of course.
Yes.
And somebody got the bright idea that, well, gosh, they're going to need some better screening technology to get because they're using, well, and specifically, they're using these trays and having you put your shoes and your laptop and a bunch of stuff in trays, and the trays are going one way across security. And there's a fellow who said, hey, I've got an idea. I'm going to make a patent. I've got an invention. And my invention is a cart that you can take the trays back in. Maybe I'm oversimplifying.
You're simplifying it maybe a little much.
Okay, let me get to my question, and you can explain to me.
Sure.
So basically, he patented this, and TSA said, and in his patent, he says like, hey, this is better than what they're doing now. And TSA apparently agreed. They started using his method, but they didn't want to pay him for it. He had in fact, all he was asking for was the right to put advertising on the trays. He didn't even want money at first. He just said, let me put advertising on the trays, and I'll let you use my invention for free. And TSA said, no, we're just going to use it anyway, because that's not patentable. You're just putting stuff on trays. How is that a patent?
So
Matt, here's my question for you.
Yes, there's a question coming.
The question is there a patentable invention here?
Maybe.
Well, actually, let me give our audience one more fact,
okay.
which is that a court found there's a patentable invention. This is why I want to talk to you about this.
So my answer is going to remain maybe, but keep in mind, this patent was filed in 2003, in July 2003, so not long after September 11th, 2001, and it was examined in the normal course of events at the U.S. Patent and Trademark Office. After that, there was a lawsuit over it, and it was upheld. And
so the court said, yes, this is a valid patent.
Well, first the USPTO said, yes, your invention meets all the criteria for.
Matt, why don't you describe what's in this invention? Like, what exactly do they get protected?
So there's a bunch of. Here's how a patent works and the parts of a patent. There's a lot of text. There's drawings. While they're strictly optional, it's crazy not to include any. So there nearly always are drawings that illustrate the parts that go together and how they go together and what happens in whatever the patent is. A better mousetrap, a rocket ship, anything. And then there are claims at the end. And the claims look like strange, grammatically strange run-on sentences.
That you patent lawyers write, and you with your magic and your...
Our magic patent speak.
Yeah, right.
Yes.
And I believe Eye of Newt and Toe of Frog, you throw that in there too?
Only if they're part of the invention.
Okay.
And only if you introduce them in the text and the drawings. Okay. So when you say what's in the patent, there's multiple answers. There's what's in the text and the drawings, and there's what's in the claims.
Okay,
and the claims,
what have they claimed here?
Hang on one sec.
Okay.
And the claims in an issued patent are what has survived examination at the USPTO. I haven't gone through and read what's called the file history of this patent.
Let's skip to the chase.
I just want to say it's highly likely that there were plenty of other claims written based on the material that he put in the text and drawings. What got issued are 15 claims, one independent, and then a bunch of additions to it.
Okay, what's the independent claim?
It's for a system of having 2 trays. Can I have your coffee mug, please? I like to demonstrate things.
Hang on first.
I like to demonstrate things with graphics.
Delicious.
It's for a system.
Just don't confuse them, because
I'll do my best.
I don't want patent lawyer germs.
Well, this may actually be a challenge. It's for a system of having 2 carts around a scanning machine. This here is a scanning machine, conveyor belt. You put a tray on. I don't know if this shows up in the shot.
Yeah, no, I think we got it.
Position it like this. Okay. You put stuff on a tray. It goes through a scanner. Then the tray, you take your stuff, you leave, you go through the airport. The tray goes on a cart here. Then, when this cart is full of trays, you switch them.
Yes. And this is my water. Thank you, Matt.
This is your water.
Okay.
And the trays that were emptied are now at the front of the scanner machine, and people coming into the security line can pick up a tray, put it on the scanner.
I got a couple questions about this, Matt.
You probably have more than a couple, and you should.
Right. Okay. My first question is, I know that things that are already in the public domain, that folks are already doing, that's not patentable. So why is this not in the public domain, Matt? That's my first question. And while you're answering that, the second question is, if it is in the public domain, why isn't it obvious? Because I know that if something is, even if it's not being done already, if it's obvious, it's still not patentable.
So there's a few hurdles to patentability. One is whether or not something is new, meaning are all of the elements of a claim described in a single other patent? unless
Or
someone,
in the public domain, though, right?
well, yes, but public domain as that phrase, public domain, isn't what comes up in patents. It's just whether or not something is known.
Okay.
It's similar to public domain, but it's not like it has to be dedicated to the public.
Let me ask you
No,
this.
It's not
what
like
about prior art, though?
hang on. It's not like something has to be dedicated to the public in the way that a public domain work is in copyright. It's just that something is known. It could be private. It could be owned by somebody else. But if it's known, and a single newspaper article or a single scientific journal article describes something, then it's not new.
Swapping two things in a closed-loop system, was that not known?
Well, it probably was. But keep in mind a couple things. One is that the standards, the hurdles for getting a patent issued, one is novelty. That's what we were just talking about. Two is obviousness. That's the one you're asking
And three
about.
is utility. I'm asking you about one and two.
Three is actually disclosure now. It used to be utility, but now it's, do you describe and show the thing well enough that someone else can do it?
Oh, that's interesting. They've changed number 3.
Yeah.
Okay.
I mean, it's the same, but it's described differently.
Okay.
So
So let's go with
obviousness
novelty.
standard.
Let's start with novelty. Is this even new? Does it even pass that first hurdle?
That's not quite the right question to ask about it. The question to ask is, was this new when the patent was, well, when the invention was made? Because this...
As of the priority date of the patent application.
Yes, and keep in mind, the patent laws changed, phasing in between 2010 and 2012. This was filed before then. So for this one, the relevant question is, was this new and also non-obvious when the invention was made? Which is a little fuzzy, but we know that that's prior to July 2, 2003, because that's when it was filed.
Okay.
And probably after September 11th, 2001.
Fair.
Because the patent talks about that date.
Okay.
Or the lawsuit
So
was it new when the invention was made? I'm not sure. I'd have to go and look. Now, the other question you want to ask is,
was it obvious?
Was this obvious when the invention was made?
I mean, just it seems to me to be pretty obvious, but obviously the judge disagreed. What do you think, Matt?
Well, the USPTO first disagreed that it was obvious. You know, they read the patent materials. They look through other patents and patent applications, whether they were still pending.
They granted a patent for this, which
They
seems
did.
crazy to me. Talk me down, Matt. Is this a...
It's hard to talk you up or down, Ken. First, because, you know, convincing you of something is sometimes a challenge.
Oh, you're very persuasive, Matt.
On occasion.
Give me something to hang my hat on here.
The thing is that as the judge on the Court of Appeals for the Federal Circuit, because a lawsuit over infringement went up to the appeals court for patent cases, as that judge said, it's tempting to apply hindsight to whether or not something was patentable at the time that it was either invented or filed, depending on what year. It's tempting to apply hindsight, but that's the wrong framework to look at it, because we don't know, and we can't know, without looking at all of the evidence that was available to the patent examiner and to either the applicant or the attorneys or the attorney for the applicant, the patent applicant. We don't know what else was there. And while I prepared for our discussion on this topic by reading the patent, I did not have time to go and read what are probably hundreds, if not thousands of pages of materials for that. Let me read you the claim, just the first independent claim, just so you get a sense.
There's only one independent claim here, right?
That's correct. There's only one.
So everything else, if this falls, all the dependent claims are gone.
Well, not necessarily. Because what often happens in patent examination is your independent claim, which you write as the broadest description of your invention, you know, with the fewest number of components, say, or steps.
Right.
That one might be deemed either not novel, or it might be deemed not non-obvious, so obvious.
Sure.
But your dependent
Not
claim...
non-obvious. Love those double negatives.
Well, you know, it's patent speak. The dependent claims might still survive one of those challenges.
Really? Oh, interesting.
Yeah, just because an independent claim is ruled not patentable, having the additional limitations from one or more of the dependent claims might get it over
They could survive.
those hurdles.
So, okay, I interrupted, Matt. You were going to read the independent claim.
Yeah, so it's a method. I'm going to summarize it as I go because it's wordy. It's a method for having the first tray cart at the head of a scanning device, having a second tray cart at an opposite end of a scanning device, taking a tray from the first cart, putting the tray through the scanning device, then at the second tray cart, putting the tray, now emptied, or not necessarily, it doesn't say that,
Okay.
putting the tray on the second cart,
Okay, I got it.
and then moving the second cart back to the first
Oh
position.
my God, that just seems so obvious.
I'm reluctant to second guess other attorneys or the USPTO because this work is difficult.
Okay.
And, I don't have the background. But I see a couple of ways that I'm surprised that this claim was upheld. First, the removing a tray from the first tray cart part, that now, under current examination standards, would very likely be dinged as what's called a method of organizing human behavior. Meaning you can't get a patent for things that people do. If it's a person,
Picking up a pen.
picking up a pen, right? If it's not a person doing it, if it's a robot doing it, okay,
You can get a patent for it.
probably. I mean, you got to get over all the other
Right,
hurdles.
right, right. It's potentially patentable.
But the part where it's just a person moving things around, it's hard to see how that survived. And the examination standards were
But
different
isn't that
at
an
the time.
essential component of this? I mean, it seems like there's not a lot going on here. Person puts the thing on the cart, person takes the thing off the cart. Oh, and person rolls the cart around. It's all people doing stuff.
Yeah, it does seem that way. And the patent is for the method of all of those things happening in sequence. I'm a little surprised that this one survived, that it made it through examination. One thing I can say, and this is just a hunch, is that there were lots of claims in this patent application, other claims, when it was filed, and during the course of examination, which is, as I'm sure you know,
Very rigorous and
it's
multiple.
rigorous and it's lengthy. It typically takes years. Often, minimum 2 to 3, but sometimes 5 or 6. And it's sight unseen. I think it's pretty likely that many other claims were tried and abandoned in this application or
So it's,
family of
you're saying this
applications.
is the product of compromise and so?
Yes, that's often what happens. You, as a patent attorney, you keep trying to
Well,
find patentable
kudos
subjects.
to the patent attorney who got this because they won their client a heck of a lot of money in royalties.
Well-
Matt, how much money is the TSA having to pay based on this?
That's the upshot, Ken, and I'm glad you asked because it is impressive. So keep in mind, this is for a method of moving carts and trays around security devices. Now, if anybody has ever been on at an airport and flown on a plane, you know that this happens frequently, nonstop.
And the patent covers the U.S. So how many airports in the U.S. are using this? I noticed-
About 400. About 400 airports.
and based on the royalty
period,
calculation-
the time period that's relevant is about a decade, I believe, between when he contacted the TSA and when, at some point,
Well, the patent just expired recently in like 2023, right?
yeah, about a year, about 14 months ago.
Right.
Yeah.
Late 2023 or the end of 2023.
So patent damages,
for that whole period.
For that whole period.
So as of
We're doing.
2021, in the district court decision, I think they said at that they had a
Okay.
number there, right?
I know you're sitting down. They figured that this patent was used at those 400 airports by a total of about 7.6 billion passengers. Billion with a
With a B, okay.
Adjusted down by about 2.3 billion passengers for a period where the TSA had an implied license
Okay.
to use. Again, a lot of facts, a lot of background.
Okay, fair enough.
Another slight adjustment, and you wind up with something like 5 billion and change people for whom the TSA infringes
Gets a
patent.
royalty.
The royalty rate that they came up with was 2 cents.
2 pennies for, ooh, this is big money.
It's a lot of money.
2 times 5, I can do that math.
Yeah. The number comes out to about $103 million. Million with an M. So not 100 billion,
But
not
it's because
1
we're
billion,
talking pennies, we got to divide by
but
100.
$103 million.
But that was as of 2021. There's going to be interest since then, right?
And there's interest.
And was there some dispute over the interest rate?
There was a dispute over the interest rate, over what interest rate should have been used, an interest rate from 2005, an interest rate from the interim, should it have fluctuated, who knows?
And there's
That's-
more damages accumulating since 2021 between 2021 and 2023. So the point is, ultimately, the federal government is paying this plaintiff. What's the name of the company? It was
I forget, Security Point Media.
Security Point. These guys.
Media, because what he wanted to do was put ads.
Right, he wanted to put ads in the
trays,
baskets.
On the trays.
Paying
and
the dude well north of $100 million. So in fact, you and I are paying this guy. But I mean, honestly, Matt, I find it hard to blame our federal government in this specific instance for not going, oh yeah, we'll make a deal with you. Because, I mean, maybe they should have taken some, I think the lesson here is they should have gone to a court and asked for a declaratory judgment, or they should have tried to do a procedure to cancel the patent in some way. Because if they'd gone through a patent cancellation procedure and failed, then they should have made a deal with the guy. Because using it without canceling it first subjected them, and ultimately us as taxpayers, to at least $100 million, well over $100 million, probably with interest and additional damages, $200 million in liability.
Yeah, it's real money.
Yeah, and
to the federal government, if anybody's listening, don't go infringing patents willy-nilly.
yeah. And by the
Find
way,
a patent attorney and
Yes.
ask them what to do.
That goes not just for the federal government, but for businesses and individuals as well.
Yes.
If you believe that
Thank you,
there
Ken.
is a patent in your field, get some legal advice, get an opinion letter from a patent lawyer that you're not infringing. At least then, if you turn out to be infringing, it won't be willful infringement.
Yeah.
And, you know, be innocent infringement, less damage, a lot less damages. Potentially.
Or, you know, find a way to work around the patent if you think you can. I mean, this method, there probably would be ways to arrange a security checkpoint and not infringe this patent.
Well, it's so broad, though. I mean, having a cart going one way and a cart going the other way. I mean, basically, this is mind-boggling. I think, and partly why some people would say, use the term patent troll, because they go, oh my God, this guy's suing for patent. He's not, but at least he was trying to license it. He was trying to solve a problem. So I had no problem with the plaintiff here.
I got to push back on the term patent troll. I know we've talked about this in the past. I'm sure there's.
Well, I'm going to agree. I'm going to agree with you here, Matt.
Yeah.
I wouldn't call this guy a patent troll because he was trying to do good for society with it. To me, a patent troll does not fall into that category. And
I think it's an unfair term that people use when they are being sued for infringement. This guy was trying to make a product and license it, and the federal government just decided, nah, we're just going to infringe it. Whether they're right or wrong about whether or not the patent was valid isn't at issue. It's valid until it gets invalidated, and the federal government was incredibly dumb. To just infringe this.
We have so much good stuff to get to. I don't want to get into the patent troll terminology discussion.
I understand.
But let's put a pin in it, and we can have an all-out slugfest over whether there's ever an appropriate. Because I usually agree with you that it doesn't apply, but there is a narrow band of situations where I think it's fair. We can have that discussion on a future show.
That sounds good.
And in the meantime, we got another interesting topic to talk about.
So this one, like I said at the top of the show, caught my eye because 1, it's copyright, 2, it's local government, and 3, it's about whether videos that were on a community access TV station, like New TV, which we love and are on right now, whether those were protectable by copyright. So the brief background is that this happened in Waltham.
Our neighbors to the north.
Yes, north and west. The city council had the Waltham Community Access TV station. That's the logo there. Waltham Channel, Waltham Community Access. I'm not sure what the
Community
second
Access Channel, maybe? CAC?
Yeah.
I think that might be it.
Had them take video of city council meetings and post them on their website. Great. That's wonderful transparency in government. That makes the conduct of city government available and accessible to many people. Terrific. Some guy who lived, I think, in Waltham, was taking clips of those videos and putting them on YouTube, on his own YouTube channel. And the Waltham Community Access Channel tried to stop him. Why?
At the prompting of the local government, the city council.
Yes. Why, Ken? What were they trying to do?
Okay.
And how?
So as you are well aware, of course, local government occasionally has some issues in it, right? They get people passionate. People get upset about things. And they want to shine a light on what's going on at City Hall. So this actually, I have another show, Common Ground, and we recently had a show in which we talked about the policy in Newton of having mixed levels within the same classroom in various subjects. And at high school, and this is something that's quite controversial, and one of the Newton South faculty members whom we had on Common Ground wrote a terrific op-ed in the Boston Globe as to why this wasn't good for any of the students involved, and there's a lot of parents that are objecting to it. And what did we do on New TV? We showed a clip of the school committee meeting at which this policy was discussed when it was implemented a decade or so ago.
Okay.
Right? And how are we able to do that? Well, we were able to do that because it's a record of a city meeting. And so this is a case of either overreach or misinterpretation of copyright law. First of all, if something is a record of a public meeting, like for example, if you have a docket of a meeting, or you have the minutes of a public meeting,
right.
That is a public document, and in fact, you can file a public documents request with City Hall to get it. What they're arguing is, oh, no, this wasn't a public document because it wasn't the city's recording.
Let me pause you for 1 second, just so I understand, and for our listeners. Those public documents, like the minutes of a city council or school committee meeting, are they not protectable by copyright?
They are not protectable by copyright.
At all?
No.
Period?
Because
they're just not protectable by copyright?
They're not protectable by copyright because their purpose is to record a public record of something that you're able to access, right?
And so it should be dedicated to the public, so anybody
it's
can
the
make...
whole point.
So anybody can make copies
You
of
can
it.
You can copy the Board of Aldermen reports docket or committee reports to your heart's content. If you email it to your friends, you are not committing copyright infringement.
I could print up pamphlets.
You could print up copies of City of Newton, City Council, minutes of meetings, or for that matter, the congressional record or records of state legislative meetings.
Oh, like the Massachusetts legislature's records?
Yes.
If they've made any public?
Well, they do have paper copies, so you could go in with your camera, take a picture, and post them online, right? If you wanted to spend your entire life going through committee reports, right?
Yes.
Or you had a friendly state rep who gave you a copy of something. You could distribute that. So in other words, records of the truth is, the Massachusetts legislature has some funky rules where they've exempted themselves from some public records. That's another topic for another show.
I know.
But let's focus on the municipal.
Waltham.
With City of Waltham or the City of Newton, same situation here. A recording, like if there's a audio tape, in the old days when I was on the Board of Aldermen, we had audio cassettes of our committee meetings, and anyone who wanted to could get a copy of that audio cassette. They'd have to pay for the blank cassette, essentially, and you could hear, your own copy of the tape of the Programs and Services Committee. We now put them online in digital form.
Now you're talking about the city's
meetings.
Records.
These are
like the city's records. Like the city makes an official recording.
So Linda Finucane, who is the clerk of the Land Use Committee, would literally press record on a tape. Now, what the argument here is...
So let me just make sure I understand the distinction. If I went to a Newton City Council meeting and I took out my phone and I recorded a video or audio...
You own the copyright.
That's my own material. I own the copyright in that recording.
Now someone else might have some fair use. You put it up online. They might be commenting. So there might be secondary rights. There might be exceptions to infringement. But on a base level, you own the copyright to that.
Okay. So in Waltham, what happened?
So the distinguishing characteristic that this Waltham Community Access Corporation argues is they say, we're not the city government, so that public document doctrine doesn't apply here. But the fact is, they contracted, they're the agent of the city government. That is the official recording. Just as here in Newton, and this is particularly important to Newton residents, who are among our viewers, of course, the New TV makes the official recordings of city meetings. You can no longer even get audio only. They're not making that. They're not press and record on an audio file for a lot of these meetings. New TV's record of many meetings is the only record. It was the only record we could get of that school committee meeting.
Okay.
And so that's their first mistake, right?
So that Waltham Community Access is not like...
They're the keeper of a public record.
They're not like me going to a city council meeting and taking a video on my phone.
Right.
They are the agent, the outsourced
They are the agent of the city of Waltham. So A, there's no copyright protection.
Got it.
But
That's
B,
what I was trying to set up with that example.
Thank you. Well done. But B, even if they were, for people to distribute that, to comment on it, would not be copyright infringement. Now, of course, there was they posted this on YouTube, And so Waltham Community Access Cable issued a takedown notice request under the digital. Okay.
Let me ask you about that, because
To YouTube, to Google.
To YouTube, which is owned by Google, I know. So I'm familiar with that, but for our viewers...
Yes, of course, you're very familiar.
Yes. Waltham didn't have to run to a court to try to get YouTube and file a lawsuit to try to get YouTube to remove the videos that Channel 781 had posted. They went to YouTube and did what?
They sent a demand, essentially, under the Digital Millennium Copyright Act. Now, this is really interesting. Congress does a lot of things, and I think this was a pretty smart thing they did. They said, look, if you're going to host a big community of files, you don't want to be sued for secondary copyright infringement every time one of your users posts something. So if you're Google or Facebook, or at the time, MySpace,
right,
or whatever, I think it was like long before, YouTube even.
Yes.
You want to be able to let people post things, but then you don't want infringing copyright stuff to stay there. So what it said is, if somebody says, hey, that's infringing, you have a time period in which you can take it down, or you can say, no, it's not infringing. I've looked at it, and I'll take responsibility for it. It's called a safe harbor. And what the city of Waltham, not the city of Waltham, but what Waltham Community Access Cable did is said, you better take this down, YouTube, or you're going to be liable. Google will be liable because it infringes. Right. And Google said, oh, okay, we don't want to get in the middle of your fight. We'll honor that. And there's been a big issue, not just here, but throughout the internet, about overuse of takedown requests.
Right.
And because lots of things that are not copyright protected are being silenced as a result. Someone doesn't like what they're basically silencing other people's speech that way.
Right.
And so here there's actually a lawsuit about it that's emerged, I believe will almost inevitably turn out in favor of the user who took this material, because there's no plausible argument, and I assume it'll be decided on a dispositive motion, a motion to dismiss for failure to state a claim that we were talking about earlier, because they are the keeper of the public record. They don't get a copyright to it. Just as New TV does not own the copyright. Even though they operated the cameras, they were making the official record of a city meeting. So a city council record, New TV does not. They're a licensee. They're acting at the behest of the city, essentially, for that purpose.
Right.
So my prediction is Waltham Community Access Cable will not prevail in this action.
Interesting. Well, stay tuned, sports fans.
Another potential sequel.
Yeah.
And of course, hopefully that sequel will never take place in New, and I know it won't, because New TV would never have the hubris to try to stop this. In fact, I know that because they've been cooperative with fair use of their videos.
Yeah. No, it makes sense. I mean, like I said, I saw this come across somebody's blog, and I thought, wow, that's really an amazing bit of overreach by the Waltham Public Access Channel to try to stifle somebody else's speech on something that is city records, city material.
Well put, Matt. Let's talk Public Domain Day.
Oh, yeah.
So much. I want to ask you about, let's start out with a topic I want to call a farewell to royalties.
Ah, yes.
So Matt.
I'm so glad that you.
Tell me about a book or a work of literature or a play that entered the public domain just a couple weeks ago on January 1st.
Almost exactly 4 weeks ago. Yeah, so the first one we have is Ernest Hemingway's book, A Farewell to Arms. I'm delighted. Not that I'm planning any
derivative works?
Any derivative works or world building around the characters in this book, but maybe I will.
You could write a play.
I could.
Or a movie.
Or a movie, yes.
Short story.
Yeah. Ernest Hemingway is one of my favorite writers, and this book is now 95 plus years old, and it's in the public domain. This is the cover of a first edition print of it.
So that's also in the public domain.
It's also in the public domain, which is why we used it, and we're sure to put on the screen, which you can see.
Image sources, Ernest Hemingway, A Farewell to Arms, first edition.
There you go.
Well done, Matt.
Thank
you. Nice
yeah.
point there.
So next up, I know more stuff is coming in the public domain. Ken, I have a question for you.
Mm-hmm.
Are you what you are?
I am what I am, and that's all that I am.
Excellent. Because what has entered the public domain now?
Not the song, the character Popeye. So I love this story. This is a terrific public domain story.
Yeah, we were talking about this, and I understand the author, the original creator of Popeye is Elzie Segar.
Yeah. So I want to say, first of all, Popeye was not his own main character in a comic book to start out with. He was a minor character in a different comic series. And this is the panel we have on the screen is the first time he was introduced in 1929. And what's so interesting about this, you'll see a fundamental misunderstanding of the public domain all over the internet. If you Google Popeye public domain, you'll see a plethora of articles. Or a veritable plethora, I'm not sure.
Plethora.
It might be a veritable
You
plethora.
keep using that word.
I'm not sure this word means what you think it means. Unfortunately, not in the book. Anyway, but you'll see a lot of articles where they say that you can use Popeye, but you can't use his power-up. You can't have him getting quick to the finish because he eats his spinach.
Right.
In other words, you can't have him.
Sailor Man.
Yeah, you can't. You can't have him eating spinach and getting strong because that wasn't introduced until like 4 years later.
Okay, and let me ask you about that because on first glance, that sounds plausible.
Yes.
Because just like we've talked about with Mickey Mouse, the Steamboat Willie edition of Mickey Mouse entered the public domain last January 1st, 2024. But not all the later versions and appearances of Mickey Mouse character because those were created later, and so they haven't become part of the public domain yet. Why doesn't that apply to this, to Popeye? And you can see here, he looks a little different, and as you say, he doesn't eat the spinach, he doesn't use spinach as a power-up until, I'm trying to do math, 91 years in the past.
Something like
95
that.
minus one.
Yeah,
Okay.
yeah, something like that. Well,
Why is the spinach in the public domain now if it wasn't introduced?
one word, Matt.
Yes.
Formalities.
Oh, that's one of a lawyer's favorite words.
Okay, so prior to 1978, you didn't get automatic copyright registration when you fixed a work in a tangible medium of expression, which is how you get copyright protection these days. In other words, you write something, you write your book, you write your letter, you make your painting, immediately it is copyrighted. You haven't registered the copyright,
Right, it's protected
but
but not registered.
It is protected immediately and for a period of the life of the author plus 70 years if you're an individual, or for corporations for a slightly different period of time, potentially. But the point being that back then, prior to 1978, you had to register it, and you had to there were a lot of formalities. You had to put a copyright symbol on it, and you had to put the copyright symbol, the year, the author name. There were all these formalities, and if you messed them up, you lost protection. And then you had to renew the copyright. Initially, it was a 13-year term, then it was a 26-year term. They've adjusted it a few times. But after 1978, no more formalities. But things from before 1978 that were not renewed, that were not in active copyright, where the copyright wasn't active as of 78, they didn't get resuscitated. There was a narrow band of exceptions, which were the subject of some litigation. But basically, once your copyright was dead prior to 1978, it was dead forever. So what happened was a whole bunch of the comics from a few years after this, including when Popeye first ate spinach. I'll hold this up. This is among them. This is, I'll read the panel and then hold it up. It says, "You licked my best men. You broke out of my jail at will. You escaped from a ton of rope. How are you able to do such things?" This is this gentleman talking to Popeye. And he wrote, he says, "That's easy. I eat spinach." So this is the introduction of the Popeye power-up concept years later. This particular comic was not subject to copyright because the formalities were not observed. This comic has been in the public domain for many decades, for more than half a century. So the question, of course, that follows, do you want to ask it or shall I pose it?
Yeah, so can you have some other character have a spinach power-up?
Okay, well, that's a good question, too. The one I want to answer first, then I'll get to that
okay.
one. The one I want to answer first is, why wasn't Popeye in the public domain years ago, for more than half a century? The answer is because this is a derivative work of that, right?
Right.
So you only got what's new in this panel. So the power-up with the spinach was in the public domain.
As of let's say like 1950 or so.
Whenever the renewal wasn't
whenever they
filed.
failed to
file their
comply
26-year
with the renewal.
Right.
Okay.
More than a half a century ago,
So
right?
you could have had some other character, say.
And you probably could have had another character power up anyway. So this raises a really interesting question. And I know, Matt, you and I were discussing this over lunch.
We had a very fun conversation about this.
So what about Superman powering up from the yellow rays of the sun? Could you have another superhero? Where did you come down on this? Another superhero power up from yellow rays of the sun? Would that be copyright infringement of Superman?
I don't think so. But it's hard to know. It doesn't seem like it's that big a part of the character of Superman.
Does that make that person a Kryptonian? I mean, it
depends. Do you write or draw, whatever the format is, whatever the medium is? Do you make them an alien from another planet who looks like a human but on Earth has superpowers?
I think you've hit the nail on that. See, my view on it is you'd need at least one additional element, probably 2 or 3 additional elements from Superman. Maybe that person has a disguise and goes by the name of Clark Kent.
Right.
You could have had.
If you stack up the elements, then
Right.
You're potentially infringing more than just a de minimis amount, a tiny
Right.
amount of the character and the world.
So powering up from rays of the sun, I think you could, if you made it a blob creature that grew in the sea of the earth and nothing else, and then it came to the surface and got powered up by the sun,
Right.
I think you'd probably be okay as long as it didn't work at the Daily Planet.
Right. If you just had some other human who happens to, anytime he or she gets a sunburn,
Right.
get powered up and get
yes.
superpowers.
Sure, if they were exactly I agree with you 100%. So the bottom line is Popeye is in the public domain, and his powering up with spinach is in the public domain. By the way, Olive Oil is also in the public domain because she was in this comic before Popeye, which I love that she was a character before Popeye was. So you can do Popeye and Olive Oil. Oh man, but we got only a couple minutes.
We got to wrap up.
We got to get to the next topic.
We have just a couple more public domain items.
Oh yeah, I want to ask you about this one. Are Happy Days here again, Matt? In other words, can we use that song?
Well. In the sense that you can use this song and do whatever you want with it, yes. Because now the song is in the public domain.
Let's hear it.
The sheet music also is in the public domain.
The sheet music is what was copyrighted in 1929.
Yes.
It is in the public domain. And fun historical fact, Franklin Roosevelt used this song as his campaign song in 1932, but he had to license it because it wasn't in the public domain.
Yes, and unlike some other presidential candidates, he actually sought to get permission to use it.
Yeah, no, like
he wants to use.
Right. Okay.
So anybody can use this song now. You can make parodies, you can make derivative works.
You can play it at your bar mitzvah.
You can include it in your next Taylor Swift or Beyonce hit. Go for it.
All right.
And the last up in our hit list of
one of my
public domain
favorite movies or sets of movies.
Yes, The Coconuts.
Okay, so this is the Marx Brothers' first feature film. They'll all be entering the public domain in coming years. Let's just show a quick clip that is now in the public domain. Very quick. Let's watch this together. Uh-oh, we need sound.
Mainland. Viaduct. I'm all right. How are you? I say here is a little peninsula, and here is a viaduct leading over to the mainland. All right, viaduct. I'm not playing Ask Me Another. I say that's a viaduct. All right, viaduct. It's what that viaduct. Why no chicken? I don't know why no chicken. I'm a stranger here myself. All I know is that it's a viaduct. You try to cross over there in a chicken.
Anyway, it's goofy, but it's classic Marx Brothers, and you can see some of their better movies are kind of derived from the same direction. But this movie, you can show it wherever you want. You can use the characters from it in the public domain, and of course, all the Marx Brothers material. The best stuff was over the next decade. It'll all be coming into the public domain. So, end of the show.
Add that to my list of things that are
Right.
coming.
So here's we teased this earlier, Matt. What are you most looking forward to coming into the public domain next 10 years? I told you mine's The Hobbit. How about you?
You know what? I'll get back to you next month. I haven't actually thought about it during the show.
All right, fair enough. We've been busy. Well, thank you very much for watching. Thanks, Matt.
Thanks,
it's
Ken.
fabulous fun chatting with you.
Always a pleasure and fun to talk about issues in the news.
From a legal perspective. And please, folks at home, join us again next time, which will be the fourth
Tuesday of February.
Fourth Tuesday of February, where we will indeed talk about issues in the news.
From a legal perspective.
And not only that, let's also thank, of course, our fabulous crew.
Yep.
We have John Fremer directing tonight. We have Will Carlisle. Thanks to Kathleen and all the fabulous people at New TV. And thank you at home for watching.